I I want to turn our attention to our next speaker. And as a prelude to his remarks, I just want to give a little bit of historical context to how where we are today in the crusade for equal rights. A brief overview would tell you that in 1961, President John F. Kennedy, by way of an executive order, established affirmative action to ensure applicants to the federal government would receive fair treatment in and during their employment. The order also established the agency known as Equal Employment Opportunity Commission that would investigate claims of workforce discrimination. In 1964, President Lyndon Johnson signed the Civil Rights Act of 1964, a landmark piece of legislation that prohibited discrimination against any individual based upon his or her race, color, religion, sex, or national origin. Our state did not get into the arena of affirmative action until 1972. There were efforts to get the state legislature to establish by law an affirmative action policy and program, but that failed. In 1972, Republican Governor Dan Evans established the affirmative action program for our state by way of executive order. He is a titan. I recently met him at an event that was held a month or so ago, and he recalled for us the events leading up to his execution of that executive order. Later on in 1998, the voters of Washington passed a ballot measure referred to commonly as Initiative 200, which says in the voters pamphlet that was distributed statewide, it was intended to prohibit discrimination based on granting preferential treatment on the basis of race, sex, color, ethnicity, or national origin in the areas of public employment, education, and contracting. And then within 30 days of that ballot measure passing, on December 3rd, the then sitting governor issued a directive mandating that all state agencies eliminate all affirmative action programs. And I want to emphasize, it said eliminate affirmative action programs. That's not what the ballot measure said. The directive also encouraged all higher education institutions to follow the governor's lead in adopting policies consistent with the 1998, December 3rd, 1998 executive or governor's directive. Finally, after a quarter of a century where affirmative action was wiped out in the state of Washington, Governor Jay Inslee on January 7, 2022, issued Executive Order 2201, which in essence rescinded the 1998 governor's directive, which eliminated affirmative action. And by issuing that executive order this year, the door was reopened to the state of Washington re-embracing affirmative action. That is the bit of background I want to share before bringing on our next speaker. And I want to give some background to the person you're about to hear. Noah Purcell is the Solicitor General for the state of Washington and part of the top tier, I think second in line in the state Attorney General's office. Noah was appointed to that position in 2013 by Attorney General Bob Ferguson. As Solicitor General, Noah has represented the state in some of its most important cases, including Washington versus Trump, the state's successful challenge to Donald Trump's first Muslim travel ban. He led the state's cases against the Trump administration and has argued cases on behalf of the state in the U.S. Supreme Court, Washington State Supreme Court, and trial courts around the state. Prior to becoming Solicitor General, Noah worked at a law firm, Perkins Coie, where he handled voting rights acts cases around the country. He also served in the Department of Homeland Security, the General Counsel's office during the Obama administration. He's one of ours. He's a local. Noah attended Seattle Public Schools, graduating from Franklin High School in Seattle. He received his undergraduate degree from the University of Washington, where he was actively involved in student efforts to oppose what? Initiative 200. After graduating from the UW, Noah received a master's in economics from University College, Dublin, and a law degree, magna cum laude at Harvard, where he served as an editor of the prestigious Harvard Law Review. After law school, Noah served as a law clerk to U.S. Supreme Court Justice David Souter. He lives in South Seattle on the same street where he grew up. He and his wife met in high school at Franklin and have been together ever since. They have 3 children. And Noah, with all of the things he has on his plate, has served and as a volunteer coach with the Beacon Hills Youth Soccer and the Franklin High School mock trial team. And he is a longtime supporter of the food bank at St. Mary's, Seattle's Central District. I present to you Noah Purcell, a person who is on the rise because he's not old yet.
Well, thank you, sir. I appreciate the very kind introduction. I get older by the day with the 3 young kids. They give me new gray hairs pretty much every day. So it's wonderful to be here with all of you. I'm honored to be here on behalf of the AG's office. And I was asked to talk about the status of affirmative action in Washington, which Mr. French gave you kind of a some of the key developments, but you know, there's a lot to talk about, honestly. And so I'm gonna try to keep my presentation to about 15 or 20 minutes, and then answer questions if folks have them. And also, obviously, if folks have questions for the prior speakers, that's great as well. So why don't we start with, and I should say it's great to see Francis and so many other wonderful folks on the screen here. So among friends, which is wonderful. So first, let me just talk a little bit about the AG's office. You know, I think it's important to understand that the way we approach issues like affirmative action is from a deep commitment to trying to do everything we can within the law to advance diversity, equity, and inclusion within our own office and within state government as a whole. So I just want to talk briefly about that and about our roles before moving on to the law. So within our office, since Bob Ferguson took office in 2013, we created a civil rights division, which had never existed in the AG's office before. And that office has grown substantially and has done very important work all over the state. We've also more recently created a racial equity unit to do things like training within the AG's office and to help us work with our clients on their programs. That's also something that had never existed before in the AG's office. And we've made significant progress on improving the diversity of our attorneys, which has been a wonderful development and important, obviously, for the office to reflect the diversity of the state. So that's just a little bit about kind of where we're coming from in terms of our goals internally. And then if we can go to the next slide, I'll talk some about, you know, most folks understandably don't spend a ton of time thinking about exactly what the role of the AG's office is. You hear about us in the news sometimes, but that's kind of a limited slice of what we do. So I just want to talk briefly about our different roles, because I think it's important to understand that. So one of the very important things we do is we control affirmative cases, affirmative litigation that the state brings. So for example, if we sue opioid companies for you know, the dangerous and illegal ways they marketed their drugs in Washington, that's a case that we've chosen to bring. The Attorney General can make that decision on his own. We bring that case and we control it. Our civil rights work is the same way. our antitrust cases, like our recent lawsuit against Albertsons about their payout to a bunch of private equity companies. Those sorts of cases we control, we bring them. They tend to get a lot of attention, but it's just one part of what we do. Most of our attorneys spend most of their time advising and representing state agencies. And so everything from the Department of Ecology to the Department of Children, Youth and Families to, you know, the Apple Commission and everything in between, the universities, obviously. And so that's a different role because in that role, you know, the agencies are in general the policy decision makers, for the most part answerable to the governor, but not always, depends on what agency it is. And our role is more as their attorneys. We give them advice, we advise them, and we call it options-based advice. We give them legal options. We try to present the risks of different options, but being clear that ultimately it's their decision what policy choices they want to make with our input on the law. As you can imagine, you know, some sorts of, well, a lot of the work we do in terms of civil rights, like I talked about before, the civil rights work, our civil rights cases, we control. What policies agencies want to adopt for affirmative action measures is, you know, almost entirely within their control with our legal advice. So I just want to be clear that that's our primary role in terms of affirmative action programs, whether it be, you know, higher education admissions, contracting, and so on. So with that background in mind, I'm going to move on to what our office does and the status of affirmative action in Washington. And the short answer is it's complicated. I'm going to focus today on contracting because that was my understanding of what the focus was here. So let's, I just want to start by saying there are things we have to pay attention to in both state law and federal law when it comes to affirmative action and what the state can do. And I'm going to talk about both today because they're both important to understand kind of where we are now. And if we can go on to the next slide, I'm actually going to start with federal law because, you know, understandably, a lot of folks focus on I-200, which was a huge blow to affirmative action efforts in Washington. But there were other limits that predated I-200 that are important to understand just to make sure folks don't, you know, that folks understand where the different constraints we're operating under come from and what we can control as a state and what we can't control. Sadly, we cannot control the US Supreme Court. I wish we could because they've made a lot of terrible decisions in this area over the years. But one of the main limitations on the state's ability to use affirmative action measures is decisions of the US Supreme Court interpreting the US Constitution. And what the US Supreme Court has said essentially is that the Equal Protection Clause of the 14th Amendment places very strict limits on the use of affirmative action in contracting. I personally think that those decisions are wrong and misguided, but I'm not in charge of the US Supreme Court, unfortunately. So if we can go on to the next slide, I'll talk some about what that looks like in practice. So states are allowed under federal law to use affirmative action measures in contracting, but the state has to very specifically identify the industry in which the discrimination is occurring and who's being discriminated against. So it's not enough, for example, to say there's a long history of discrimination in the construction trades or in construction contracting generally. It has to be more precise than that. And any program designed to remedy that has to be tailored to kind of specific groups that have been discriminated against as opposed to more broad categories. And I've included some quotes. You know, obviously there's a lot of words on these slides, and I'm sorry, I hate slides with a ton of words on them, but I just wanted to kind of give a flavor of what the US Supreme Court has said about these topics. And then if we can go on to the next slide. Another key element is that before states can use affirmative action programs, they have to try kind of every reasonable race neutral alternative first. Affirmative action programs can only be used as a last resort, in the words of the court. And also basically what is allowed are essentially flexible goals for standards the state is trying to meet in terms of, you know, percentage of contracts that are awarded to minority contractors, but quotas are prohibited. So if we can go on to the next slide. So I guess I just want, you know, so that all comes from federal law. Whether we pass an initiative or amend I-200, none of it will change that. That sadly can only change with a different Supreme Court. You know, so just, I just want to be realistic with folks about what, you know, what that means. Now, that said, there's a lot that we can control as a state, and unfortunately, you know, we've made some poor choices over time, and starting with I-200, which passed while I was a student at the University of Washington, and I've included some language from I-200 there in terms of exactly what it said, but I do think it's important to understand the kind of the implementation of it and how it's changed over time. So as Lynn said, if we can go on to the next slide, Governor Gary Locke, right after I-200 passed, issued a directive 9801 that interpreted the initiative quite broadly. And in terms of contracting, said, and there's a quote I've included here, that basically race, sex, color, national origin just cannot be used in the selection of a bidder for a public contract. And that was essentially the law of the state for a long time after that. But if we can go on to the next slide, the first important development in kind of changing that perspective came in 2003 when the Washington Supreme Court addressed a case about the city of Seattle's, the Seattle School District's use of tiebreakers, racial tiebreakers to attempt to diversify schools in the city. So essentially, where there were too many students who wanted to go to a particular school, the district would use race in an effort to balance out the diversity of different schools in the district. And the plaintiffs in that case argued that that violated Initiative 200, and the state Supreme Court said, no, it does not. I-200 prohibits discrimination and preferential treatment. So what they, and as you can see, I've quoted this there because I think the exact language is important. What they said is that it prohibits discrimination where race or gender is used by the government to select a less qualified applicant over a more qualified applicant. So that's what the state Supreme Court says about I-200 and what it means. So then quite a long time goes by without much changing in practice, to be honest. And then if we can go on to the next slide, and then in 2017, the governor asked our office to issue an opinion about kind of basically how I-200 should be interpreted now. And I apologize again for the very long quote, but I was trying to give a flavor of what our opinion concluded. So AG opinions, for folks who don't know, are, and most people don't know, so don't feel bad. AG opinions are essentially when an elected official, such as the governor or a legislator, asks our office to give our best reading of the law about a topic. The AG opinions are not binding on anyone, so they don't control anyone's conduct, but they are given a lot of weight in court. And so what we said was that I-200 does not categorically prohibit all use of race or sex conscious measures in contracting. And it allows a variety of steps like using race as a tiebreaker between people who are in the same category of qualifications, and also in narrow circumstances, an agency can use affirmative action or race or sex conscious measures when no other means is available to remedy demonstrated discrimination. And I should say, on top of all this, you know, of course, agencies can use the sort of outreach measures and efforts to eliminate subconscious bias and all sorts of things that are designed to root out conscious and subconscious discrimination in their hiring and contracting processes. But so we issued this opinion in 2017. And then if you can go on to the next slide. And then just this year, Governor Inslee decided to eliminate Directive 9801, which Lynn talked about, and issue 3 new executive orders that call for a variety of steps in public contracting, in hiring, and in higher education, and also just within state agencies in terms of developing equity plans, anti-racist commitments, and steps and measures that agencies will take. So that was a lot of information in a short period of time. If we go on to the last slide, I think it sort of sums up, and I'll try to leave plenty of time for questions. So the ultimate bottom line for now, and this glosses over a lot of detail, but that's, I think, you know, the way it needs to be for a presentation like this, is that, you know, we're still constrained by federal law, but federal law does allow use of certain forms of affirmative action where there's documented evidence of discrimination in areas of state contracting. I-200 is within the state's control. That, you know, the legislature could amend it, the people could pass an initiative to change it, but as it is, it restricts but does not eliminate the state's ability to use affirmative action. And in particular, it allows use of affirmative action to select among equally qualified bidders, or where there is no other way to remedy demonstrated discrimination, or where doing so is required by federal law. And the last thing I'll say, and in some ways, maybe the most important message I want to get across, is that, you know, so given everything I've said, there are ways to implement affirmative action programs still in Washington state, despite I-200 and despite some terrible decisions of the US Supreme Court. But it is a bit of a legal minefield, and agencies need to be very careful that they do it right. And that means, for example, having evidence, you know, specific evidence about the discrimination that's being remedied and who's benefiting from the program and how it's going to be implemented. And so, you know, we have been trying to convey to our agency clients that we stand ready to work with them to do everything within the law to advance diversity, equity, and inclusion efforts and implement affirmative action programs. Ultimately, you know, it is up to the agencies, and they have been told by the governor that they need to do this, but ultimately it is up to them to make the policy decisions to implement these programs with our legal help. And we, you know, are actively working with a number of them on options right now, but you know, again, I guess I just want to emphasize that our role in that sort of policy decision for them is to give them legal advice. We can't force them to do anything. We can help them. We can help them do things on this front. And with that, I think that is my last slide. So hopefully I've made up some lost time, and there's plenty of time for questions about either what I've covered or the SBA, or for the SBA folks.
Thank you, Nora. I would like to begin by having the staff. We have some AHANA staff who are helping to collect and organize the questions, and Marvel, I think, has ready access to the written questions. I have one before Marvel jumps in, and that is, if the state were to establish a set-aside program for contracting with socially and economically disadvantaged groups, A, would that program be considered an affirmative action program? And B, from what I know, all races can participate in such a program so long as they're socially and economically disadvantaged. So white males, white females, and every other race, if they qualify under what the SBA uses as criteria, which is income or revenues received, they can participate in a program federally, like the 8A program. Is that something that could be done in Washington without having to deal with the hurdles of affirmative action?
Well, I think the devil would be in the details, and I'm always a little nervous about giving legal advice in a forum. But I guess what I would say is a lot would depend on who was eligible and how it was structured, right? If it was explicitly race-based and you know, only limited to members of certain minority groups, then I think, you'd run into a lot of issues with I-200 and potentially with federal law. If it were more like what you described, where, it's on its face, it's race neutral. There's a definition of disadvantaged businesses that allows for members of any background to potentially qualify. That's a lot easier to defend under both state and federal law. So I think it is theoretically possible. You'd have to, I think, be very careful about how you designed it. And I think, like I said, it's a good example of how I think there could well be a way to do it, but you'd have to be extremely careful in the designing of it and what language you use and in how you define who's eligible. Because you're right. I mean, most of the federal programs that people call, set aside programs, they are open to, well, number one, there's targeted goals. They're not quotas, right? It's not like 10% of the contract is going to go to this or that group. They're targeted goals. They have relatively broad eligibility, but they achieve important goals. And so I think something similar could potentially be consistent with I-200 and could be done under state law. It would just have to be done very carefully.
Right. And the key thing that I've learned is that proportionality is important. So all races would be represented, but there would be a balancing between each race in terms of the percentage or number that are actually enrolled in such a program, but none would be excluded.
And I think the key part is that no one is excluded off the bat based on their race for purposes of federal law and I-200. I think the more explicit a program is about percentages directed to different racial groups or different scoring, like different numbers of points based on the applicant's racial background, the harder it gets to defend under both state and federal law in terms of what the state is doing.
Thank you. Marvo.
Thanks, Lynn. I do have this one question is, what about the governor's executive order 2201? Will it encourage agencies to begin actively contracting with BIPOC firms? Won't that open the door for more BIPOC firms receiving contracts?
I think there's a lot in the, oh, sorry, I didn't mean to interrupt. Is that
I was going to say this, I'm addressing this to you, Mr. Purcell.
Okay. Yes, I mean, I think it on several fronts, it should have that effect. It directs every agency to take steps that were identified in, without getting too deep in the weeds. There was a disparity study conducted in 2019 where the governor's office hired a firm to basically analyze steps the state could take, analyze how much state contracting deviated from the diversity of the contractors available to do the work and in different areas. And it identified a number of steps that the state and state agencies could take. So the governor's directive, among many other things, required each agency to review that study, to review the steps that it outlined, and to take any of those steps that the agency could. And a bunch of agencies, I work primarily with the governor's office directly, less so than with each individual agency, but I know that there are many, many state agencies that are actively working on implementing those steps. And I also think that and it also just, I think, helps send the message that agencies that this is a priority for the governor, that agencies should reach out to us for help about how to implement affirmative action efforts within the law. Some larger efforts, like I think what Lynn was asking about, would probably require legislation, would require a new bill that would, explicitly create new contracting rules or goals. But there's a lot that agencies can do within existing law, given the governor's directive.
Thank you.
Yeah, without, I mean, I don't want to talk forever, but I think, 9801, the old order, was a strong disincentive for agencies to take steps, and that has obviously been eliminated now, and they've gotten the opposite message.
Great. I do have a question for our SBA team here, since we still have them online. How would a state program similar to an SBA 8A program be different from our Office of Minority Women, OMWBE, Office of Minority Women Business Enterprises? How would it be different from OMWBE?
They might be able, this is Joel with the SBA, they might be able to best answer that question. However, I do know that the focus of the SBA program is in goal setting. And as Marvo and anybody on the call in business, is some of the agencies that we've visited with since our SAM, they have an intention of being emphasizing equity and diversity, and it's implied, but they, as you and I think have learned through this process, they don't set goals. And the difference there with the SBA program is that we have set goals. Now, there's no punishment necessarily if agencies don't hit those goals, but the procurement officers do pay attention to those goals. And unless you set goals, what are you going to achieve? So goal setting is a really important part of the SBA program that is the background for that 8A program. And I'm not personally 100% familiar with the OMWBE program. I do know that they do certifications for various groups, but as far as differences, I would think that would be it. And I would be certainly open to discussing, further.
Great, thank you. There was a question in the Q&A that was asked, and I guess this is really addressed to SBA more on a federal level, because I don't know that we can answer it at this point on the state level, regarding, are there efforts being done to unbundle big contracts to help small multi-ethnic businesses gain the contracts versus being a subcontractor under a primary? And I think that Fernando put a post in there, and Fernando, if you would you like to reply to that?
Is he on the call still?
I still see him on. He may have stepped away, but if I don't know if you are able to answer any of that, Joel.
So I'm just scrolling down to see if to look at what Fernando's answer was here. I don't see that question.
It's under the answered questions. Very bottom.
Similar to the SBA 8A or different from the OMW. Are there efforts being done to unbundle big? Okay. On the federal side, we do have, as John mentioned, the Mentor Protege program, and that's for a small business, a business who's become large, who wants to give a helping hand to small businesses, and they work with them as mentors to get them into federal contracting. So we are doing that and unbundling big contracts. That is a growth issue for a new firm into an 8A program. And I'm just looking here. And Fernando responded, basically their efforts to minimize bundling in federal procurement. So government agencies shall make a written determination that the bundling is necessary and justified in accordance with what he quoted as 15 USC 644E. So the answer to the question is yes. And if you can see in the questions answered, the efforts through federal acquisition regulation.
Thank you, Joel. Lynn, I'm going to push it back to you if you may have another question for Solicitor General Purcell.
I don't have another question, so I'm gonna look to the panelists to see if there are any questions they might have.
I saw one in the chat about whether the state uses data that we gather for other purposes, like through DSHS, to identify potential contractors or I think that was it. Do we use the info to automatically enroll or start enrollment for small business owners? And I'm afraid I don't know off the top of my head what all the state does on that front. The governor's office is hosting a summit. I think it's November 30th, where one of the goals is to, and it's I believe it's at the Tacoma Convention Center, to talk about ways, new kind of next steps that the state can take after with 9801 rescinded to expand diversity, equity, and inclusion programs within state agencies, and I'd encourage folks to attend and participate in that. I do know that some agencies, there's either state or federal laws that limit how information can be used. As you can imagine, sometimes the state gets information that is meant to only be used for particular purposes. I'm not saying that blocks all efforts like that here, but it is something we have to keep in mind, that not all information we get we can necessarily use for all purposes. And then the other constraint, of course, is just that, as you can imagine, a lot of our systems, unfortunately, are not the most high tech, and so sometimes there's just work that needs to be done to make systems communicate with each other and such. So something that seems like it should be easy is sometimes not as easy as we would hope for it to be in terms of information sharing.
I do have a question from Attorney Jesse Wineberry, and his question reads, has Attorney General Bob Ferguson filed a statement of additional authority with the U.S. Supreme Court since the court's October 31st hearing on affirmative action, informing the justices that Washington State rescinded race-neutral affirmative action policies established by Governor's Directive 9801?
We have not. Normally, only the parties in a case file statements of additional authorities without getting too deep in the weeds. So those cases have to do with the affirmative action programs at Harvard and the University of North Carolina.
Right.
And the state of Washington joined an amicus brief along with many other states supporting the affirmative action programs that UNC and Harvard have in place and supporting their legality. So we have not filed anything since the argument about Executive Order 9801. Honestly, most of the states that joined that amicus brief have more robust affirmative action programs than we do, because they don't have an equivalent of I-200 on the books. So, because we're not a party to that case, we're just kind of supporting the main parties. It would be a bit out of the ordinary to file a statement of additional authorities after the argument, but I'm happy to talk to Representative Wineberry about that separately.
Okay. With regard to the SBA 8A program, question for the SBA representatives is, when goals are established by federal agencies for set-asides for the 8A funds, if an agency fails to meet its goal or leaves money on the table, do they get to spend that money for something else? Does it go away? What happens when they come short of their goals?
Well, what happens, what ostensibly would happen is, if they didn't hit the goal for awarding of the contracts, those contracts could have been awarded to a non-8A or a non-minority firm. So the money gets spent. Our intent is to set goals for spending of that money by percentage to disadvantage. And as you saw, I think it was in John's presentation, those goals are being increased by the federal government for contracting agencies, which are, like Department of Defense and what have you.
So follow up.
The money gets spent, it just doesn't get spent where we're asking them to spend it necessarily.
So what's the accountability? If I'm an agency and I just don't want to do it, I'll just go spend it somewhere else. So are they voluntary goals or are they mandatory goals?
There's, I would say somewhere in between. And the SBA does a review of each agency for the federal government. So every year they're reviewed on their achievement of those goals. And there's a grading process. Lynn, it's not, they don't necessarily get penalized, but there is a grading process, and it is, there are not financial penalties that go along with that. But Fernando, I don't know if you wanted to add something to that. I saw you pop back on.
So as a prior contracting officer working with the Air Force, these goals are kind of just set as the preliminary, and you can kind of see in our scorecard in the link, primarily for the small business category, the federal government agencies usually surpass the 23% portion. It's more of, the other category areas of whether it's being women-owned small business, hub zone, 8A, or veteran-owned small businesses, that sometimes they don't quite meet the mark. And then, as you can see in some of the situations in the case of us for the state of Washington, you have some data that are kind of skewed because we have Boeing in our state, which is primarily is a large business and takes up, I believe, around 48-49% of acquisition dollars being spent over the past 5 years. So when you have an anomaly such as that, it's hard for some states to meet the goal because so many of the acquisition dollars are being spent to a large business in that specific state. But overall through the national portion, we are meeting those goals. So like I said, that's for that portion. As for the accountability piece, I know working with the Air Force, that was one of the big things that we had to kind of justify why we didn't meet those standards how are we held accountable? So we were having to basically justify any standards that we didn't meet. Primarily that was the Hub Zone program, where we historically have challenges meeting that 5% goal. That is something that our small business specialists in our unit had to substantiate what we did to target Hub Zone businesses, and then our plan to target more Hub Zone firms in the future. So it's kind of like a get well plan for agencies that they have to submit to their MAJCOMs, their major commands, and then they work together to kind of within their own specific agency to have corrective action plans to mitigate them from falling below the standard percentages that are set for our goals. I hope that answers your question.
That's helpful. Definitely.
Lynn, I want to just there were a couple in our Q&A that are more of a reply. So regarding from OMWBE, they say that they do actually set goals with their agencies as written in their statute. They'd be happy to meet to discuss. They also say that, yes, we now have a DES supplier diversity policy that engages with leadership to ensure that they understand the prioritization of supplier diversity across the state. So I just want to make sure that those two statements were given. One other quick question. I'm going to do it because I know that we want to do a quick 10-minute break before we get into our next section at 3. Is that the question is there a way to make it easier for OMWBE agencies to have the same information or to use the info to automatically enroll or to auto start enrollment with small business owners? I think that that's going to be answered best directed towards OMWBE. Wouldn't you think, Lynn?
Yes, I think so. I'm not prepared to answer that for them myself.
Yeah, and we certainly our committee, our task force committee, can certainly forward these questions to the correct agencies and get them answered. So I'll turn it over to you, Lynn.
Okay, I just
for a
have one
10-minute break.
final question, and I apologize, Noah, for not having a citation, but there were some affirmative action laws passed in the state of Washington during the time of our illustrious Senator George Fleming, who has since passed. And I wonder, they were established in statute. Are they effective now? Because I thought they was simply overwritten by 9801, and that would typically not be legal from what I understand. But I'd like to get your thought on existing affirmative action laws that are currently on the books.
Yeah, so there are a couple, that's exactly right. And Representative Weinberry might have the citations closer at hand than I do. But there's some of them are in the chapter about the Office of Minority and Women's Business Enterprises, which is, I think, chapter 3919. No, I mean, those are, I-200 did not repeal any of those laws. And an executive order cannot take laws off the books. One complicated topic that comes up a lot in our office is, well, what happens when a law passes later that is in some conflict with laws that are passed earlier? How do you assume that it intended to override those, to wipe them out, or do you just kind of try to read them together as best you can and make them, you know, in the normal rule from court decisions is that you try to read them as consistent with each other. So, you know, that's one of the reasons I think why it doesn't make sense to read I-200 as just outright prohibiting affirmative action, is because those laws are still on the books. It didn't mention them. It didn't eliminate them. So they are still there. They're you know, they're limited as a, you know, they're not kind of a full-on description of what all state agencies should do, but there are some useful points in them, and I think that's a very good point about what, you know, those laws continue in effect today. They still should be guiding agency actions, and I think that's, you know, one of Representative Weinberry has been reminding everybody about that, which is very helpful, because I think they honestly, I think a lot of folks just kind of forgot about them for a long time because they weren't. You know, after I-200 and Executive Order 9801, you know, I think a lot of agencies just felt like they couldn't do anything. You know, they couldn't do anything, which was, you know, an overstatement and very unfortunate. And I think we're starting to move back in the other direction of trying to be as creative as we can be about what we can do within the constraints of federal law and I-200.
Very much appreciated. And we are now at that point in time where we will take a 10-minute break. It is 2:54. We'll come back at 3:05. So please check your clocks, rejoin us. We have our legislative leaders, Senator Andy Billick, Majority Leader of the Washington State Senate. We also have Representative Tim Ormsby, who is chair of the House Appropriations Committee. In addition, we have Representative Marcus Richelli, who is the majority whip in the House of Representatives. And not the least of all, we have Representative Monica Stonier, who is the majority floor leader in the House of Representatives. And everybody should know, legislation 101, you don't get a bill through unless it goes to the floor leader. So we're looking forward to the conversation with them, and please rejoin us at 3:05. Thank you all very much.